Hello everyone and welcome to this video tutorial on parliamentary lawmaking. This is from Exam 1, Section A. For this topic, primarily we're looking at how bills become law, but you also need to have an understanding of parliamentary sovereignty, separation of powers, the rule of law, and the different influences on Parliament. To begin with, it's important to look at what Parliament is. Sometimes students confuse Parliament with government, but these are two very different things. Parliament, you can see here from this diagram, is made up of three central elements: the House of Commons, the House of Lords, and the monarchy. The main business of Parliament takes place in the two houses, and generally the decisions made in one house have to be approved by the other. The main functions of the UK Parliament are to check and challenge the work of the government or scrutiny. They make and change laws, legislation. They debate the important issues of the day, and you often see that on the news, them all shouting at each other. And they check and approve government spending, budget and taxes. In terms of composition then, we've got the House of Commons here, the one you see on the news quite a lot, and the House of Lords below. The House of Commons is the elected chamber of Parliament, and it's made up of our elected MPs, each of which represents his or her constituency, meaning the part of the country which has elected them and which they represent. The House of Commons has the role of choosing the Prime Minister, who is proposed by the Queen and has to command the Commons' confidence. MPs are members of different parliamentary parties, such as Labour and the Conservatives, and they advocate the same political goals and lobby together. The House of Lords here is the second chamber of the UK Parliament. It's independent from and complements the work of the elected House of Commons. Members of the House of Lords are often referred to as peers. Up until 1999, the Lords was largely hereditary chamber, with peers inheriting their titles. The 1997 Labour government pledged to remove hereditary peers, but to ease the legislation's passage, the Lords was instead allowed to elect 92 peers from amongst the hereditaries. So what that means is approximately 11% of peers are hereditary at the moment, with 86% of peers being life peers who hold their titles for their own lifetimes but can't pass it on to their offspring as they previously used to do. The remaining 3% of peers include 24 bishops, archbishops, who sit in the Lords as the Church of England is the UK's established official church. Of the UK Constitution, unlike most modern states, Britain doesn't have a codified constitution. Instead, it has what we call an unwritten constitution, which is formed of lots of separate acts of Parliament, court judgments and conventions. There are arguments for and against having a written constitution, like the US has, for instance. One of the most important arguments in favour of having a written constitution is the fact that enshrining our constitutional laws and customs in one document would provide clarity for those working within the system and those who wish to scrutinise it. The argument in favour of a written constitution is checks and balances. At the moment, our judiciary is relatively weak in its ability to act as a check against Parliament, and a written constitution would increase its power. It would also be more accessible for citizens and potentially protect its citizens from an overpowerful state. The opposite side of the arguments against having a written constitution, is that if it was written, it'd be difficult to change. And one of the benefits of the current system is its flexibility. In countries like the USA, it's nearly impossible to change their constitution. People have also argued that the unwritten constitution is part of our heritage, and that it has managed to function quite efficiently and pass the tests of time in being a long-lasting system of governance. Many people believe that the system of an unwritten constitution works and works well. But because, of course, we don't have a written constitution at the moment, there are a number of conventions or key principles which are extremely important for our unwritten constitution. So we're going to have a look at each of these: sovereignty, rule of law, and separation of powers. Parliamentary sovereignty, or sometimes known as parliamentary supremacy, is a really important principle of the UK Constitution. It makes Parliament the supreme legal authority in the UK, which can create or end any law. And in its most simple form, sovereignty is the principle of absolute and unlimited power of Parliament. According to Dicey from 1885, parliamentary sovereignty consists of three elements. Parliament may make or unmake any law it wishes. No Parliament can bind future Parliaments, and no one may question the validity of an Act of Parliament. There are, however, limits on parliamentary sovereignty. When we joined the EU, some of our sovereignty was handed over to Europe because EU law at the moment takes precedence over UK law. Obviously, that will change now that we've decided to leave the EU. There is at the moment a transition period still in existence. There's a case that we'll look at in EU law called Factortame, and this illustrates that EU law takes precedence over UK law because in this case, the European Court of Justice actually suspended a UK Act of Parliament that conflicted with EU law. So this undermines Dicey's theory that no one may question the validity of an Act of Parliament, because obviously at the moment the European Court of Justice can. Another limit on parliamentary sovereignty is the Human Rights Act, because when we enacted this Act, it was to bring the European Convention on Human Rights into UK law. And under Section 3 of the Human Rights Act, judges are required to interpret law in accordance with the European Convention on Human Rights. And if they can't do that, if our law is seen to be incompatible with human rights, the judge is able to make a declaration of incompatibility under Section 4. So again, the fact that we follow the European Convention is also another limit on parliamentary sovereignty. Final limit on sovereignty is devolution, because our Parliament is no longer sovereign over the domestic affairs of Scotland and Wales since the Scotland Act and the Government of Wales Act. And they can make their own laws for their own countries. And recently, with the coronavirus pandemic, we've actually seen Scotland and Wales introducing some of their own rules on lockdown, etc., that are different to perhaps how England has dealt with it. So these are the three limits on sovereignty. So that's the theory, but it isn't absolute because we do have limitations. Something that's really interesting to think about at this point is whether Boris Johnson attempted to limit parliamentary sovereignty when he prorogued Parliament, and that prorogation was challenged famously in the Supreme Court in a very important case. In R on the application of Miller and the Prime Minister, the Supreme Court was asked to review Boris Johnson's suspension of Parliament. He tried to suspend Parliament for 5 weeks, and it was alleged that his decision to prorogue was an abuse of power. And this had to be reviewed by the Supreme Court. And this is the lovely Brenda Hale here. And the Supreme Court reached a unanimous decision that the Prime Minister was acting unlawfully because when he prorogued Parliament, he was frustrating and preventing Parliament to carry on with its constitutional functions without reasonable justification. Arguably, of course, Parliament does not have absolute power if one man can prorogue it, suspend it. So this is a case example of Brenda Hale standing up for parliamentary sovereignty, and she did actually refer to sovereignty of Parliament in her judgment. And there is a link to the full judgment in my PowerPoint, so I recommend you go away and watch that because it's really interesting. And as I've said, a massively important decision for the UK Constitution. The fundamental principle of the UK's Unwritten Constitution, as well as sovereignty of Parliament, is the rule of law. And the idea of the rule of law is that the law should apply equally to all rulers and ruled alike. And Dicey explained 3 components of the rule of law: that there should be no sanction or no punishment without breach. One law should govern everyone, no one being above the law, and that rights of individuals need to be secured by judges. And a very important act of Parliament, the Constitutional Reform Act of 2005, recognised the rule of law and the importance of having an independent judiciary in achieving the rule of law. And if we think back to the case I just mentioned, or on the application of Miller against the Prime Minister, that's a nice example of rights of individuals being secured by judges. Fundamental principle of our unwritten constitution is separation of powers. And in order for a democratic government to function properly, it is essential to have separation of powers. And this means that power is distributed to separate branches. And we've got three branches of any state recognised by Montesquieu. We've got the legislature, the executive, and the judiciary. In explaining this theory, Montesquieu said, quote, "There is no liberty if the power of judging is not separated from the legislative and executive. If it were joined to legislative power, the power over the life and liberty of the citizens would be arbitrary, for the judge would be the legislator. If it were joined to executive power, the judge could have the force of an oppressor." So what he's saying is that these arms of state have to be separate so that one person doesn't get too much power. The diagram shows the three branches of power then. So the executive, consisting of the Crown and the government, including the Prime Minister and the Cabinet of Ministers. It also includes the civil service. And the executive mainly formulates and executes government policies. And government is accountable to Parliament, which has ultimate power to dismiss a government and force a general election. The legislative power in the UK is held by Parliament. And the Parliament of the UK, as we know, is composed of three parts: the monarch, the House of Lords, and the House of Commons. We know that the main functions of Parliament are to create and amend law, scrutinise the government, and to enable the government to make financial decisions. The main function of the judicial power is to hear upon and resolve the matters of law. However, in the UK, the judiciary has one more essential function: to develop the law through their judgments. The judiciary consists of judges in courts as well as those who hold judicial office in tribunals. Ideally, the judiciary must be independent of both Parliament and the executive, so that it is able to act as a check on both of these powers. The example that we've already mentioned of the Supreme Court acting as a check on the executive was this massively important case, or on the application of Miller and the Prime Minister. And that was useful when we were looking at sovereignty of Parliament, but it's also relevant here to separation of powers, because when the Supreme Court was asked to review Boris Johnson's decision to prorogue Parliament for 5 weeks, the judiciary was acting as an important check on the executive. So Brenda there was keeping Boris in check. And that illustrates just how important it is to have separation of powers so that one person doesn't become all-powerful. It's important to remember that the Constitutional Reform Act has strengthened the separation of powers by limiting the role of the Lord Chancellor and creating the Supreme Court. Remember, before we had the Supreme Court, the House of Lords not only was part of Parliament, but it was also the highest court. And that was a problem because, of course, the House of Lords was being involved in the judiciary and also in the legislative body. So that was improved by the Constitutional Reform Act, which got rid of the House of Lords as the highest court and replaced it with the Supreme Court. Another good thing that the CRA has done is created the Judicial Appointments Commission, which is an independent body responsible for appointing judges, rather than the old system where the Lord Chancellor just appointed his mates, basically. So again, this is important in terms of separation of powers, because we want an independent judiciary. We want someone like Brenda who feels in a position that she can make a decision against the executive without fear for her job. And one final feature of the Unwritten Constitution just to be aware of is the royal prerogative, which has been defined by some sources as the special rights, powers and immunities to which the Crown alone is entitled under common law. And these are historic powers officially held by the Queen that have in reality been passed to politicians. So this was our first video tutorial on parliamentary lawmaking. Please watch the next video tutorial on how a bill becomes an Act of Parliament.